चश्मे बाहर ही हैं. A very good evening to all of you. Hello and welcome, guys. My name is KP Singh and I welcome one and all to the 30th episode of Weekly Law Scoop. So let's wait for a couple of more students to join in. Welcome, Arya. Welcome, Harshita. Hello, Charu. Chale, guys. So I think we are good to go. Okay. Can you guys please confirm if the audio is fine and all of you can see the screen? Welcome, Pooja. Welcome, Dimple. Welcome, Dedya. Welcome, Harshita. Chaliye, thank you. Chaliye, guys, let's start. So as always, I would ask all of you to select the best quality option available in your system. Just click on the settings tab and pick the best option that you can see. Okay, guys, the first news item that I want to discuss today is Supreme Court's recent verdict in which they applied contra pro frentem maxim in an insurance contract. So Supreme Court bench comprising of Justice U.U. Lalit and Ravindra Bhatt and P.S. Narasimha recently held that if there is any ambiguous term in an insurance contract, the first attempt should be made to go for a harmonious construction. That means interpretation which is suitable to both the parties. But if the first rule is not giving us satisfactory result, then court will have to apply contra pro frentem. That means the interpretation which suits the insured person shall be preferred. Title of the case is Harris Marine Products versus Export Credit Guarantee Corporation Limited. So let me give you brief information about the factual scenario here. So Export Credit Guarantee Corporation is a government company which provides range of credit risk insurance cover for exporters. So if you are in the business of import export, it is considered a very high risk segment. Most of the exporters generally take insurance cover for their consignment. So Export Credit Guarantee Corporation is one such company which provides insurance in this segment. Harris Marine Products is the applicant or appellant in this issue. These guys were engaged in the business of exporting fish meat and fish oil. On 13 December 2012, Harris Marine paid a premium for a policy and they wanted insurance company to cover the risk of foreign buyer failing to pay for the exported goods. So in case the buyer is not making payment on time, then they can recover amount from the insurance company. The vessel set sail on 15th December. However, the bill of lading was prepared on 19th December and the date of dispatch was mentioned as 13th December. So these dates are important if you want to understand the storyline of this case. So Harris Marine, they took insurance from Export Credit Guarantee Corporation. They were exporting fish meat and fish oil to offshore buyers. On 13th December, they paid a premium for the policy. So the company thought that their consignment is now fully insurance covered. Though the goods were dispatched on 19th, bill of lading mentioned date as 13th December. So eventually the goods were delivered, but the buyer defaulted in making payment. And thus a claim was filed by the insured person, but the insurer rejected the same. So he was not given compensation, he was not given insurance amount. What is a bill of lading? It is a very commonly used term in import-export segment. It is a document which is issued by the carrier to the shipper to move a shipment. The information in BOL is critical. It will contain all the important details such as quantity of good, quality of good, details of the consignor, details of the consignee, details about the carrier. It serves as a contract and a receipt, and that document is a legal proof that the carrier had received freight and is obliged to transport and deliver those goods in good condition. Well, so what is the point of contention here? the insurance company believes that the contract came into execution from 16th of December. That means after the bill of lading was already signed. The bill of lading mentioned 13th December as the date. Harris Marine paid insurance premium on 13th December. So they were of this belief that their consignment is now completely insured. Matter went for an appeal. The insured person, that is Harris Marine, approached the National Consumer Dispute Redressal Commission, which rejected their claim. Prior to that, an independent review committee also rejected their claim, and hence these parties reached the apex court of country. So now they were in the Supreme Court. Here, Harris Marine's claim was that the word dispatch as defined in the policy did not clarify the effective date of initiation of the coverage. So policy में तो mention नहीं है किस date से coverage शुरू होता है, and therefore because there is no clear definition, the condition would be interpreted to mean the date on which vessel set sail, यानी जिस दिन ship रवाना हुआ है, that is 15th of December. So 13th December they paid premium, 15th December the ship set sail, but on the bill of lading, the very important document, date mentioned was 13th December. Insurance company is saying that because your insurance started after 13th December, that is 14th onwards, we are not going to pay you insurance money. Respondent says that we are a government company and thus we are bound to follow rules and guidelines set up by government departments. So we have Directorate General of Foreign Trade, which is a statutory body in our country, and they form all the rules and regulations for the promotion of foreign trade. They have created a guideline, detailed guideline, and as per the interpretation of those guidelines, date mentioned on the bill of lading shall be considered to be the date on which insurance contract commences or starts. So what is your take on this issue? Should we give him money, or should the insurance company pay up, or can they get away with the responsibility? So many more students have joined in, so now I feel much better. Welcome Asta, welcome Akanksha. Okay, chaliye. Asta, thank you so much for that comment, Asta. And yes, I do miss taking regular sessions. We'll move on. Chaliye, so in this particular situation, court relied on multiple foreign cases. So they relied on Rainy Sky SA versus Cookman Bank, which is an American case law, where a British case law, where the British Supreme Court decided that while interpreting any ambiguous term, if two constructions are possible, then the one which is consistent with business common sense ought to be preferred. So if you apply common sense in this particular situation, if you are taking insurance, what is the primary consideration in your mind? किस चीज के लिए आप इंश्योरेंस ले रहे हैं? बिल ऑफ लेडिंग के लिए, डिलीवरी के लिए, ट्रांजिट में सेफ्टी के लिए, या पोटेंशियल बायर के पेमेंट ना करने के लिए? So in this case, insured person availed insurance because there was a risk that the buyer will not pay up. Chale, so another case law on which they relied is an American, again a British case law called Woods versus Capita Insurance, where it was held that while interpreting, the court must consider contract as a whole. So insurance agreement, insurance contract is a commercial contract. So generally, any guideline imposed by a third party shall not be applicable on the contracting parties. So applying these principles, the Supreme Court of India finally held that the date of loading goods was of lesser significance than the date on which the foreign buyer defaulted. So even if 13th December was mentioned on the bill of lading, this contract got frustrated on 14th December when the buyer defaulted on payment. So even if Supreme Court says that even if we take insurance company's interpretation, still they will have to pay money. Why? Because the default happened on 14th Feb and not on 13th. Policy was contemplated to cover the default and not the transit. So what was the risk that the insured person was trying to cover? They were worried that the buyer will not pay money. So in this case, Supreme Court applied rule of contra pro frentem. I have already explained it. I will take you through it once again quickly. It says, while interpreting ambiguous terms in a contract, more specifically in insurance contract, first attempt shall be made to go for harmonious construction. That means a construction which is beneficial to both the parties, which is agreeable to both the parties. If still the contract remains vague, then the term must be interpreted in favor of the insured, that is against the drafter of the policy. चलिए, ये तो बहुत simple facts से मैंने आपको बता दिया. Now there is a question related to it. Why do you think principle of contra pro frentem is applied? What is the rationale behind it? क्यों लगाना चाहिए? Why shall we interpret ambiguous term against the drafter of the policy? Why? So if you have ever if your parents have ever bought any insurance contract, you would know that it is more like a form with a few fill in the blanks, wherein you need to put in your name, your details, and then you get to sign that agreement. Do you get to make changes in that standard form of contract that you have presented? Generally, no. So in a situation like this, one party is having undue advantage, and the party which drafted that agreement might have drafted it in their favor. So insurance contract, policy contract generally drafter को favor करते हैं. इसीलिए if there is ambiguity, courts will try to favor the person who was at disadvantage at the beginning, and therefore this rule of contra pro frentem is applied in a situation like this. Moving on. Another controversy which was creating a lot of buzz in last week, or let's say couple of weeks, is from Maharashtra. There is a fringe political party called Maharashtra Navnirman Sena, and the chief of that party is Raj Thackeray, cousin of Uddhav Thackeray, the current chief minister of Maharashtra. Raj Thackeray recently gave an ultimatum stating that all the loudspeakers shall be removed from religious sites, especially mosques, and he gave a deadline of 3rd May. So Maharashtra government got worried, and Maharashtra DGP Rajneesh Seth conducted a virtual meeting of all the relevant departments, mostly police units of different districts, and he instructed all the police units in the state to strictly enforce the law and Supreme Court's guidelines on the use of loudspeakers. आप में से बहुत लोग न्यूज़ में यही चीज़ सुन रहे होंगे, देख रहे होंगे. यूपी में लाउडस्पीकर हटा दिया गया, महाराष्ट्र में लाउडस्पीकर लगा दिया गया, व्हाट नॉट. चलिए, सो ये सारे प्रॉम्प्टन शो से दूर जाके लेट्स ट्राई टू अंडरस्टैंड द लीगैलिटी बिहाइंड इट. So if Raj Thackeray is saying that all loudspeakers shall be removed by May 3rd, do you think he is such a big leader that government came into action and they started removing loudspeakers because Raj Thackeray told them to do so? Well, it is not just because of Raj Thackeray's demand, rather it is more so because of the standing guidelines issued by Supreme Court and various high courts time and again. Rather, on the issue of Raj Thackeray's ultimatum, the other political parties are claiming that it is just a political stunt. Shiv Sena MP Sanjay Raut insinuated that the MNS had raised this issue at the behest of BJP. Even a right-wing group, Vishwa Hindu Parishad leader Praveen Togadia pointed out that when BJP was in power in Maharashtra, they did not do anything against loudspeakers. So they are making noise now when they are in opposition. Well, a controversy related to loudspeaker is not new. Couple of years back, popular singer Sonu Nigam also got a lot of bad publicity because of his comment. In 2017, he said that I get irritated because I have to wake up to the sound of azan every day, and this is a type of forced religiousness. In his words, God bless everyone, I am not a Muslim and I have to be woken up by the azan, so I don't have to be woken up by the azan every morning. When will this forced religiousness end in our country? So those of you remember, this guy also faced a lot of criticism from his fans and opponents, and then he decided to call his Muslim barber friend and shave off his head. So कमेंट करने के बाद उन्होंने अपने बाल भी मुंडवा लिए. अच्छा चलिए, so this was on the lighter note. Let's get into the legal part. So what are the laws related to loudspeaker in our country? There are a couple of legislation which you need to know about. First one is Air Prevention and Control of Pollution Act of 1981. So 1981 statute defines air pollution. As they say, music is the sound that pleases the listeners, while noise is a sound that causes pain and annoyance. But what might be music to your ears might be noise to another, right? So when you're talking to your bae and whatever that person says might sound musical to you, but when a third person is listening to a conversation, most of the time it is intolerable. Chaliye, so section 2A says air pollutant is any solid, liquid or gaseous substance including noise present in the atmosphere in such concentrations as to be or tend to be harmful to humans, other living creatures, plants, property or the environment. So any solid, liquid or gaseous substance including noise which can be harmful to humans or other creatures or plants or property or the environment is air pollutant. So noise is also a type of pollutant. After the Air Pollution Act, we also created a more specific legislation related to noise pollution, which is called Noise Pollution Regulation and Control Rules of 2000. So Noise Pollution Regulation and Control Rules of 2000 gives us detailed guidelines on how and when and to what level noise can be made. So Central Pollution Control Board of India, CPCB, has established the permissible noise levels in India for various areas. So it differs from place to place. What is acceptable decibel limit in your locality might not be the same level in my locality. Well, so Environment Protection Rules of 1986, third legislation, also includes noise pollution. So under environment protection rules, government sets up standards for noise level for various things like motor vehicles, air conditioners, refrigerators, generators and construction equipment. Not just that, our courts have also pointed out or commented on this issue time and again. The Supreme Court in 2005 gave a very positive judgment. They said that all form of use of loudspeakers shall be outlawed during night time. So there is a curfew time 10 p.m. to 6 a.m. So no loudspeaker or music system can be used in a public place between 10 p.m. and 6 a.m. except in cases of public emergencies. But later on they also gave an exception to the rule. They said that occasional use is allowed. So they demarcated 15 days in a year. So 15 days in a year, loudspeaker can be used until midnight, obviously during festivals. This judgment was delivered by a division bench of Justice R.C. Lahoti and Justice Ashok Bhan. They also upheld the constitutional validity of rules that allowed states to relax sound pollution norms, including loudspeakers during festive season. So अभी नवरात्रे गए, नवरात्रे में काफ़ी states में जगराते होते हैं. So if you are from Gujarat or Maharashtra, you would know what I am referring to, right? Similarly, Ramzan is going on. So सुबह सुबह सहरी की नमाज, फजर की नमाज और शाम को सहरी की नमाज आप लोग सुनते होंगे लाउड स्पीकर पे एवरी डे. ठीक है, चलिए. So different high courts have also commented on the same issue. Bombay High Court in 2016 declared that use of loudspeaker was not a fundamental right. So though you have a fundamental right to pray the way you want to. So whether you are offering namaz or you are doing aarti or puja or jagrata, you are allowed to do all of that. But using loudspeaker while performing a prayer is not a fundamental right, as held by Bombay High Court in 2016 judgment. And it also emphasized that right to use loudspeaker or public address system was not a fundamental right under Article 25. Article 25 guarantees freedom of religion in a country. It guarantees triple P. You have a right to profess, practice as well as propagate your religion. The Uttarakhand High Court also gave a similar verdict in 2018. They said that there shall be an upper limit of 5 decibel for using loudspeaker. Punjab and Haryana High Court delivered a blanket ban on use of loudspeakers in 2019 at all public places including religious institutions. Allahabad High Court in 2020, they ruled that azan could only be recited by a muezzin. Muezzin is the officer of the mosque. That means he is the guy who maintains a mosque and he is the guy who will climb up the podium and give azan every day. So from the minaret of the mosque by human voice without the use of any amplifying device or loudspeakers. Chaliye, so this is the reason that you are reading in newspaper every day that different states reacted differently on the issue of loudspeaker. No government can go against the orders of the judiciary, so they have to comply, and that is the reason in Allahabad loudspeakers were removed from various places where loudspeakers were installed without permission, and where they were installed with permission of the authorities, government made sure that the permissible decibel limit is level is not being breached. Whereas in other states where no such judgment was passed, loudspeakers are still being used widely. But then you must say that what about the Supreme Court's verdict? Well, Supreme Court's verdict is being flouted every now and then. हर कोई इस रूल को तोड़ता है. अच्छा, ये सिर्फ religious places का नहीं है. India is a loud culture. So whatever we do with pomp and show. आपके घर में शादी है, बैंड बाजा बारात सब आता है, right? Justin Bieber came to Mumbai. पूरी रात पार्टी चला था नवी मुंबई में. You think about religious festival, you think about your cultural festival, you think about couple of friends partying together, you will still use loud music. So as I started this conversation with that statement, what sounds like a music to one person might sound like a noise to another. Chaliye, so just imagine your neighbor playing Himesh Reshammiya songs at high volume. Would you enjoy it or would you regret staying next to him? So it depends on your taste of music. Moving on. Chaliye, so a regressive judgment, I would say, Madhya Pradesh High Court recently commented that live-in relationships are causing rise in sexual offences in our country. The judge Subodh Abhyankar said that the bane of live-in relationship, a byproduct of the right conferred under Article 21 of the Constitution, is giving rise to sexual offences and promoting promiscuity and he also said that taking note of the spurt of such offences in the recent times arising out of live-in relationship, this court is forced to observe that the bane of live-in, I think this is a repetition. So the bane of live-in relationship is a byproduct of constitutional guarantee which is provided under Article 21, and it is engulfing the ethos of Indian society and promoting lascivious behavior, giving further rise to sexual offences. Article 21, that is fundamental right of life and liberty, has been expanded multiple times by the judiciary. It has been given wider connotation. So now right to life also includes right to privacy. It also includes right to live in healthy environment. It also includes right to dignity. So many other rights have been connected or read in Article 21. So judge pointed out that when people get into live-in relationship and later on when they fall out of relationship, people tend to go for anti-social behavior. Now this is this person's personal observation and we should not be picking sides here. Chaliye, so it is more like some uncle giving us his opinion on the issue which the court has already sorted out. Supreme Court to take serious view of NDMC's Jahangirpuri demolition even after status quo order. So those of you who were following news related to Jahangirpuri would know this incident. So a week back, Ram Navami and Hanuman Jayanti processions were taken out in those areas and some people started pelting stones. Now, whose fault it was, let us leave that to politicians to argue. But the point is that after that incident, some politicians from the ruling party made a statement that we will make these guys pay. So, whichever, like in Madhya Pradesh, there was a statement made by the Home Minister that I will turn those houses into rubble from where stones were pelted. So, उन घरों को पत्थर बना दिया जाएगा जिन घरों से पत्थर गिराए गए हैं. अच्छा, क्या गवर्नमेंट इस तरीके से बदला ले सकती है? Is it legal? No, they can't. Why? Because we have rule of law in our country, we have a legal system. If anyone has done anything wrong, then we can book them under IPC provisions and we can force them to face a trial. And the only branch of government which is allowed to punish people is the judicial wing. So judiciary will decide upon the punishment. So what happened here is that central government wanted to send a message to its core voter base. So they used different tactics. जितने घर गिराए गए हैं वो स्टोन पेल्टिंग की वजह से नहीं गिराए गए हैं. The reason that they gave is encroachment, that some people had set up shops by encroaching public land and therefore it was a drive against encroachment. So ये कब्जे खाली कराने का मुहिम था. It had no relation with what happened during Ram Navami Julus or Hanuman Jayanti Julus procession. A bench of Justice Nageshwar Rao and B.R. Gavai, when the NDMC gave a notice कि हम लोग तोड़ने के लिए आ रहे हैं, people went to the court, including Jamaat Ulema-e-Hind, and Supreme Court gave an order of status quo. Status quo means let the present scenario continue, let it stay as it is. So status quo is an order passed by the court as an interim relief, intermediate relief. So till the time we decide upon this issue, nothing should change. अब ये ऑर्डर भी आ चुका है सुप्रीम कोर्ट का. आधी रात को कोर्ट खुला था, सुबह पहले ऑर्डर आ चुका है, तो भी जहांगीरपुरी में घर गिराए गए. कैसे गिराए गए? दो इट वॉज बीइंग shared on television news channels that status quo order has been issued. NDMC took an excuse that we haven't received physical copy of that order. हमारे पास अभी तक ऑर्डर हाथ में नहीं आया है and therefore we will continue or we will do what we were supposed to do. So in a way they are using rules to breach rules. ठीक है, so this is what happened there. We'll move on to another news item. UK Parliament triggers contempt probe into PM Johnson. So British Prime Minister Boris Johnson is now facing the heat in British Parliament. The reason being that while entire country was under lockdown, Mr. Boris Johnson was throwing party at the PM house. Not just him, some of his ministers were also involved. So all those people, so just imagine इंडिया में हम सबको लॉकडाउन में डाल के मोदी जी राष्ट्रपति भवन में रामनाथ कोविंद के साथ पार्टी कर रहे हैं और अपने सारे फ्रेंड्स को भी बुलाया है. वोंट यू फील जेलस? सॉरी, वोंट यू फील रॉन्ग्ड? यस यू वुड. सो देयरफॉर बोरिस जॉनसन इज फेसिंग कंटेम्प्ट प्ली. Lawmakers of Britain approved a motion calling for a parliamentary committee to determine whether Johnson's denial of rule breaking amounted to contempt of the House of Commons in the light of his subsequent police fine for breaching regulations. So when these allegations came up, his initial reaction was just like any other politician, he denied all such claims. Later on, he was fined for partying or for flouting lockdown rules, and now British Parliament is passing a motion in which they will try to charge him for contempt. Chaliye, moving on, couple of questions, try to answer them quickly so that we can move on. Next, first question on your screen. Noise pollution regulation and control rules were enacted in which year? All these questions are from what we have just discussed. Your options are 1994, 1996, 1998 or 2000. Noise pollution regulation and control rules were enacted in which year? 94, 96, 98 or 2000. Okay, Lavanya is the first one to answer this time. Lavanya will go with D. What about others? Sanika, Harshita, Akanksha, Astha, Pooja will go with D. Dedya will go with D. Well guys, correct answer is option D. It was enacted in 2000. Right to freedom of religion is mentioned under which of the following articles of the Constitution? Right to freedom of religion is mentioned under which of the following articles of the Constitution? Your options are Article 23 to 26, Article 24 to 27, Article 25 to 28, Article 26 to 29. Okay. Harsha is the first one to respond this time. Harsha will go with B. Harshita will go with C. Harsha will again go with C. Malvika with C. Pooja with C. Correct answer guys. Sanika, that's correct. Raghav, that's incorrect. Arya, that's right. Correct answer for this question is option C, Article 25 to Article 28. Recently, which High Court observed that live-in relationships are causing rise in sexual offences in our country? Don't get disheartened. हमारी कंट्री में कई बार जुडिशरी ऐसे कमेंट्स पास करती रहती है. So isn't it full of prejudice? It is similar to that statement. जीन्स पहनने से रेप होते हैं. Can I say that marriages are causing rise in sexual offences or let's say domestic violence? शादी की वजह से घरेलू हिंसा होती है. तो शादियां ही बुरी चीज है. ओके, राघव विल गो विथ सी. इलाहाबाद हाई कोर्ट, दिल्ली हाई कोर्ट, एमपी हाई कोर्ट, केरला हाई कोर्ट. Correct answer for this one. Ujala, that's right. Raghav, that's correct. Harsha, that's right. Okay. Correct answer is option C, Madhya Pradesh High Court. So MP High Court passed this statement. Next question. The courts over the years have widened dash ambit to cover many things including the right to dignity and privacy. Your options are Article 19, Article 21, Article 27 or Article 29. Bonus points if you can tell me what all these articles say. So what about Article 19? What is mentioned in Article 21? What is in Article 27? What's in Article 29? Okay, let's see how many of you got this one right. Question on your screen. Okay, Harshita will go with option B. Harsha with B. Kashish with B. Dedya with B. Pooja with B. Yes guys, correct answer is B. Sanika, that's right. Chaliye. Okay, so Harshita says 19 has freedom of speech. That's incomplete answer, Harshita. Article 19 has freedom of speech and 5 other freedoms. So there are 6 fundamental freedoms mentioned in Article 19. Article 21, yes, right to life and personal liberty. What about Article 27 and 29? Okay, next question on your screen. During the Constituent Assembly debate, Dr. B.R. Ambedkar had said that Article Dash is the heart and soul of the Constitution and the rights given through it will always be exercised in the Supreme Court unless any amendment has been made in the Constitution. Your options are Article 14, Article 19, Article 32, Article 368. Bonus points for telling me what all these articles talk about. Harshita, Article 29, no discrimination on the grounds of caste, religion is incorrect. Kashish, Article 27, freedom of payment from payment of taxes for promoting a religion, that's correct. Kashish, Article 27 हमें मिल गया. What about 29? Okay, Article 32. Article 32, Harshita. Article 32, Ujala. Article 32. So, Sanika 32, Gargi 32. Correct answer is option C, Article 32. Article 32 is heart and soul of the Indian Constitution. What about Article 14? Acha, what is mentioned in Article 32? Why is it heart and soul of Indian Constitution? Why did Baba Saheb fell in love with this article? Okay, Article 14 talks about equality, equality before law and equal protection of law. Article 19, we have already discussed 6 fundamental freedoms. Article 32, right to constitutional remedy. Devanshi, that's right, right to constitutional remedy. Article 32, 5 prerogative writs are mentioned in Article 32. Article 368 gives the power to the Parliament to amend the Constitution. Any part of the Constitution can be amended by the Parliament using procedure prescribed in Article 368. Okay, another bonus question. Name all 5 writs mentioned in Article 32. Article 32 gives you the fundamental right to approach apex court of a country, the Supreme Court of India, if any of your fundamental right is breached. Bonus question. Name all 5 prerogative writs mentioned in Article 32. Okay. Nuthalapati Venkata Ramana is an Indian judge who is serving as the dash and current Chief Justice of India. Meanwhile, let me see if somebody answered the bonus question. Article 32, both guarantor and defender of fundamental right. That's a good comment, but not the answer I'm looking for. Harsha says habeas corpus. Yes, that's correct. Harshita says habeas corpus, mandamus, certiorari prohibition. Still one is missing. Okay, 5th one is quo warranto. ठीक है, चलिए. So, Nuthalapati Venkataramana, N.V. Ramana, is India's CJI. So, he is India's. Ujala will go with D. Dedya will go with 47, that's C. Sanika with D, Harshita with D, Harsha with D. Correct answer, guys, is option D. He is the 48th Chief Justice of India. Okay, recently which country triggered an investigation into allegations that its Prime Minister misled Parliament in his initial responses to reports that he and his staff broke COVID-19 lockdown rules? Kashish says, you have a body. No, it's not you have a body. It means produce the body or bring the body. Or to have the body. Have the body doesn't mean you have to eat it. It means to bring it before the court of law. Chale, so Australia, UK, Canada or France. Which country triggered an investigation into allegations that its Prime Minister misled Parliament in his initial response to the reports that he broke COVID protocol, COVID lockdown rules? And name the Prime Minister. Harsha, that's correct. Ujala, that's correct. Correct answer here is option B. And name the Prime Minister of UK. Who is the current Prime Minister of UK? And if I want to stretch this question, I will say, Harshita, that's correct. Boris Johnson. Who is the current President of Ukraine? If you guys are reading news, you should know this. Pretty easy question. Who is the current President of Ukraine? And who is the current President of Russia? Okay, current head of state for Japan. Vladimir Zelensky is correct answer, Devanshi. Kashish, Vladimir Zelensky is the current leader of Ukraine. That's correct. Vladimir Little Putin is the current head of Russia. Lavanya, that's right. Harshita, that's correct. Okay. The current leader of Japan is Fumio Kishida. That's also right. Fumio Kishida. Who is the current leader of Pakistan? Recent update. Current leader, current Prime Minister of Pakistan, and who is the current President of Sri Lanka. All these people have been in news recently. So new leader of Pakistan is Mr. Shehbaz Sharif, brother of Nawaz Sharif. What about Sri Lanka, current president of Sri Lanka? Harshita, that's correct. Gotabaya Rajpaksha is the right answer. Chaliye, so with this, I will take you to the last question of the day. Meanwhile, guys, please hit on that like button and don't forget to share and subscribe. If you like what we are doing, share it with your friends who cannot or who are not attending regular coaching. They can also benefit by just going through these YouTube sessions that we conduct. Which of the following statement is incorrect regarding contempt of court in India? Your options are: option A, contempt of court is the power of the court to protect its own majesty and respect. The power is regulated but not restricted in the Contempt of Courts Act 1971. Option B, the expression contempt of court has not been defined by the Constitution. Option C, however, Article 129 of the Constitution conferred on the Supreme Court the power to punish contempt of itself. Option D, none of these. Harshita is the first one to respond for this one. She says option D. What about others? Harsha will go with B. So if you're picking anything from A, B or C, you need to tell me why that option is incorrect. Harsha deleted her response. Ojala will go with B. Why B? Harsha will now go with D. Okay guys, correct answer for this question is option D. All the first three statements are correct. Factually correct. Chaliye. So with this note, this session comes to an end. Thank you so much for watching. I hope you guys like what we do. Do tell me which other topic would you like me to cover in next weekly Law Scoop. Just leave a comment once this live stream ends. So I will take care of all those case laws which you want me to cover in such sessions. Okay guys, we'll meet again next week. Bye.